The big news of the day, the big news of the foreseeable future is the Derek Chauvin trial. George Floyd was killed as a result of Derek Chauvin being there. But the question is, did Derek Chauvin cause his death? Was he a substantial contributing factor to his death? Or was George Floyd going to die anyways? And the big question is, did Derek Chauvin murder George Floyd? And that's what they're going to be trying to get to the bottom of over the coming days and weeks and potentially even months. Today, it was scheduled to start. We were supposed to start with what's called voir dire, which is jury selection, and that didn't happen. There are some pending cases, some pending issues that are being dealt with the Court of Appeals out in Minnesota, and they've got some work to do. So today was sort of ironing out some of the rules. We got through what are called some motions in limine, which are rules or motions that are set out to establish what the rules are for the forthcoming trial. And so we've got several of those that I want to break down. Sounds like some boring stuff, motions in limine and procedural type of motions, but there are some interesting things that we can glean out of this. And so before we get into any of that, I just want to show you what the current status is. What's the context? What does it look like in Minneapolis right now? And this morning and over the weekend, we saw that peaceful protesters were assembling. This article comes over from the Star Tribune. It says, peaceful protesters march in Minneapolis as Derek Chauvin trial and George Floyd's death slowed by the legal wrangling, which is kind of a fun way to put it. But yeah, it is legal wrangling going on over there. A few hundred protesters gathered peacefully outside the Hennepin County Government Center as court convened on Monday morning for the murder trial of former police officer Derek Chauvin, chanting, "No more killer cops," and quote, "Ain't no power like the power of the people." The marchers were unified in support of a conviction in the death of George Floyd, who took his last conscious breath under the knee of Derek Chauvin in May. And so it's been, we're almost coming up on a full year, about, looks like, 10 months now, since most of this happened. And of course, we saw a lot of the summer unrest unfold. And the George Floyd death really was kind of the first domino in a series of other shootings and killings and deaths that we have covered here on this channel and that we've just seen out throughout society, unfortunately, all too often. And so today, we're hopefully beginning the process of finding some closure here, though I'm not sure anybody is going to be happy with it. Let's take a look around Minneapolis. We see this sign says "Justice for George Floyd, trial in 2 days." And so it's sort of posted up on a formal business sign. You see Black Joy posted up on a flag underneath there. Major barricades, big steel walls with Black Lives Matter signs on it. We've also got some roses. Looks like that they were inserted in between the barricades. We've got a Hennepin County Government Center, which has really tall barricades. I mean, these things must be close to, I don't know, 20 feet, 18 feet. Very tall, very large bases, not going to be pushed over easily, going to be difficult to scale. We see barbed wire also being surrounding most of the facilities in conjunction with these concrete sort of traffic barricades with chain link fencing ripped on top of it. Lots of armed, well, actually, we don't see any arms here. We see police officers, 1, 2, 3, 4, 5, 6. We see a couple National Guard troops, looks like 1, 2 over there, along with some other National Guard type of vehicles and tents. We see a number of other National Guard, or at least people in fatigues, here with firearms posted up around as well. Nighttime, we've got a lot of lighting. We see Justice for George Floyd. We've got some protesters posted up over by the U.S. Bank Plaza. Not a lot of people there. Looks like just a handful of them. But then we see here a big, long memorial, big, huge picture of George Floyd sort of painted out there, or that might be a printed tarp kind of laid out. We've got some graffiti here and there. We've got some posted flowers, lot of support. Somebody here holding a sign that says Justice for George Floyd. We've got some people posting on Twitter. Looks like here they're unrolling a big scroll that has a lot of names on it. The day before Derek Chauvin, somebody posted this on Twitter, the day before Derek Chauvin goes on trial in the Minneapolis for the murder of George Floyd, 1,000 march from the Government Center and down Hennepin Avenue with a scroll that has 470 names of people killed by the Minneapolis police. 470 names, all killed by Minneapolis police. We can see a lot of these are sort of, relatively recent, at least down here in the bottom of this scroll. We have Dominic Koch, 27, died February 21st, 2021. Brian Andreen, 47, January 8th, 2021. And so, I don't know what this looks like. A lot of people. 470 names. That's a lot, and they were all killed by Minneapolis police. I'd have some questions about the surrounding of each one of those, but it's a powerful statement nonetheless. Look how long this thing goes. It goes all the way down, and now you can see the crowd is filling up. We see some signs that say defund white supremacy, justice for George. We've got another justice for George. And so a lot of individuals sort of filling up the crowd. You can see this image here, 5th Street, and something or other. Looks like there's a light rail trail that goes through here as well. And they're marching down the street. We can see here, not a huge showing, but it does look like, the crowd is sort of burgeoning as time goes on. We see a casket here that has a bunch of roses on top of it with a group of gentlemen carrying it down the street. A lot of face masks. And a lot of I can't breathe masks with BLM and Black Lives Matter signs all over the place. Another one, I can't breathe. And then we have a couple of videos that I wanted to show you. This one posted over from Samantha Hendrickson. Black visual justice scatters mirrors, flowers, and fake blood down 7th Street. Organizers say they plan to leave the mirrors here for the National Guard to pick up and look at their reflections in the bloody glass. So some very interesting imagery going on. Let's take a look at this video over from Twitter. So you can see a bunch of fake blood on the street, bunch of roses. You see some mirrors that are sort of laying there on the ground. Roses and blood scattered all over the street. Now, they're not blocking the full street. It's just sort of one lane of the street is covered with the blood and the fake mirrors. Here's another video.
They followed me. When Justin was killed, there was no Black Lives Matter. There was no movement because it was swept under the rug. And that's how it's been for the rest of our families. For Hardell Sherrill, Kobe Heisler, Codell.
All right. And then here is another one. We are going to get into the actual legal context here in a minute, but I just wanted to spend a little time showing you what is going on there right now. So this is right outside the Minneapolis courthouse. All right, so they're saying no justice, no peace, prosecute the police, which is exactly what's happening. So we'll see if this continues and how long it continues. I'm imagining that there's going to be a very strong presence of protesters here throughout the entirety of the trial. We just don't know sort of what level of intensity it will remain at. Today, of course, is a big day because they were supposed to get started and the protesters were already out in full march. So let's get into the parties here. So now that we know what's going on in Minneapolis, what the context of the situation looks like, let's talk about who is involved in this trial that we know of thus far. And remember, a lot of this stuff is still pending, right? So the government hasn't called their witnesses yet. The defense hasn't called their witnesses yet. They've been disclosing evidence that they're going to present and who they're going to be calling into court, but it hasn't been called yet. Well, the trial hasn't started yet, so we don't know exactly who is a party to this other than a few of these individuals right here. So this is what the diagram of the trial looks like. We have Judge Peter Cahill up at the top. Going to show you about him. We're going to detail a little bit about him and who he is and what he's all about. Very experienced judge, somebody who is, I think, going to be an interesting judge. I'm actually excited to see how he handles this based on what I've seen thus far. We also have Prosecutor Matthew Frank. Saw a lot of him in court today. He is the Assistant Attorney General. We're going to learn more about him. Of course, he is representing the government, the victim in this case, and this judge does allow the word victim to be used, so we'll go ahead and use that, is George Floyd. George Floyd, of course, was killed by Derek Chauvin, who you see over here at the defense table. Derek Chauvin today was in court, was masked up, wearing a little navy blue suit over there, and he was actually writing some stuff down on a notepad. He was joined by his attorney, Eric Nelson. This guy has been practicing I think since 2001. He's a defense lawyer locally there. And so we're going to learn more about these people. Now, little courtroom diagram here, you can see the jury panels over here. The defense typically sits on the bench or on the table that is opposite of the jury. And typically you want your defendant to sort of stay away from the jury. Now you can talk to other defense lawyers on how they want to situate their client. They may want to sort of do a flip-flop where they'll put their clients over on this side and the defense is over on this side. I think that's a bad strategy. Typically you want the defense sort of the furthest away from the jury that you can, so they don't really see, any facial micro expressions that could be problematic. And so this is how I have it laid out. I don't know if it is actually this way in court, but you'll have a jury panel. And so as we go through jury selection, the more that we know about the jury, we'll sort of fill this up. So we'll put some people in here. We're not going to know their identities, of course, but we may have an indication about maybe demographics or age or any of those other things. If we glean that, we'll start to fill this up. And we're also going to fill up, as this trial progresses, anybody else who seems to be like their major players in the trial. And so this is who we're working with right now. We've got a pretty interesting lineup, and it will be fun to see how they perform in the upcoming days. A little bit more about Judge Peter Cahill. Hennepin County Judge Peter Cahill was assigned to the case. Former Republican Governor Tim Pawlenty, you remember him from a while back, appointed him back in 2007. Voters have elected him twice. Former law partner Mike Kolick called his background diverse, said they met at law clerk back in the 80s. He's certainly qualified to be a judge based on all the experience he has, says his law partner. He has been a public defender, and he's also been a criminal defense attorney, which those are my people, public defenders and criminal. I was never a public defender, but the criminal defense attorneys and public defenders who are criminal defense attorneys, my people. So what does this mean for Derek Chauvin in this case? Well, nothing really. I mean, the judge is somebody who has some experience being a defense attorney. In my experience, that doesn't always necessarily equate as to a benefit for that defendant, largely because sometimes these judges, and I'm not making any, this is broad strokes generalizations. I haven't seen any indication of this from Judge Peter Cahill, but generally speaking, sometimes defendants will say, oh, good, he used to be a criminal defense attorney. He'll empathize with me. He'll understand my plight. Sometimes that works, sometimes not. Sometimes the judge, because they have been a criminal defense attorney, they have to overcompensate. And so they'll be a little bit harsher on the defense rather than on the prosecution, because the prosecutor is going, well, he used to be a defense attorney, so they're going to get all the benefits of the doubt. And the judge just overcompensates and actually is a little harder on the defense. So we'll see if that comes to fruition. Probably not. What I've seen out of this judge so far is he's pretty even-handed. He kind of is setting standards and applying them to both sides. I'm going to show you what that means as we go on. Back over to the article. Cahill went out on his own in the mid-90s. He joined the Hennepin County Attorney's Office in 1997, which is, of course, the prosecutor's office. So he started out as a criminal defense attorney, or used to be a criminal defense attorney. Then in 1997, became a prosecutor. He was the deputy chief under the county attorney, Amy Klobuchar. Amy Klobuchar, look at that name, right? So we have a Democrat. She was she was the county attorney back then, and now she is now a senator. Judge Cahill also presided over highly publicized cases. He, in 2019, Kenneth Lilly pled guilty to shooting a bus driver. Cahill sentenced him. He also dismissed charges against the organizers of a large Black Lives Matter protest back in 2015. He dismissed those charges. In his lengthy decision, he said management and security allowed it to happen in the first 30 minutes. It was a tacit decision to allow a brief demonstration. He noted that protesters made attempts to disperse once ordered. Trials in front of him are for Chauvin, charged with second-degree murder in Floyd's death, as well as the other cops who were also there. A little bit about him. He first got admitted back in October 17th, 1984. Okay, been practicing a long time. This guy's been practicing longer than I have been alive. Which, when I see these numbers, it just cracks me up. You know, I think I'm a pretty good lawyer. I think I know. I've been around the block here and there, but as long as I've been breathing, this guy's been practicing law. Okay, well, so he probably knows more than I do significantly. It's a long, long time. He's doesn't look like he's been disciplined, authorized to practice law, of course, over at the 4th Judicial District. Does not represent private clients because he is a judge. We also have the prosecutor who's assigned. Don't know much about this guy. His name is Matthew Frank. He is the Assistant Attorney General at the Office of the Minnesota Attorney General. And this is about it. This is what we got from him. This is his LinkedIn profile. Some information on here, but I couldn't really decipher much more. We do know that he is also, of course, licensed to practice law. Date admitted in October 25th, 1991. So take a look at that 91 date. He's over at the Attorney General's office, has a middle name of Glenn. That is Matthew Frank. We heard from him today. We're going to see a lot about him when we get over to the motions in Limine, because he was at the podium for a lot of the day today in court. This is Derek Chauvin's defense lawyer. His name is Eric Nelson. And this was posted on his website. This is his bio from his firm website. It says, since his admission to the bar, he's practiced exclusively in the area of criminal defense, solid reputation, skilled lawyer, successfully representing clients of all crimes, negotiation, jury trial, and the Court of Appeals. Eric's experience includes homicide, sex offenses, drug offenses, assaults, hundreds of DUI and alcohol-related traffic offenses, also represented individuals faced with civil commitment, sex crimes, represented clients throughout Minnesota, focuses the majority of his practice in Hennepin, which is where they're at, admitted to practice law in Wisconsin, represented people all over the place, frequent lecturer on various criminal law topics, including driving under the influence of a controlled substance and the manufacturing of methamphetamines. Methamphetamines are going to be in this trial because, according to the toxicology report, George Floyd did have methamphetamine in his system, or at least remnants of it. Eric routinely speaks throughout Minnesota, serves as a judge in a moot court and mock trial competitions. He has been a contributing author to the Minnesota DWI Desk Book, which is a DUI book. All right, so that's good. So he's got some drug experience, a lot of DUI experience, which is also good. That means that he probably knows how to analyze blood samples or analyze the toxicology reports that are generated from the blood samples, knows how to do those conversions and do that analysis. And so we'll see if any of that comes out during this trial. Here's a little bit more about him. So he was admitted to practice law in 2001, so a little bit younger. So the prosecutor here is about 10 years more experienced than him in terms of law. Doesn't necessarily mean anything, but he's younger, right? So he's got about 10 years less experience, but still quite a bit of experience since 2001. So he's been going at it for about 20 years himself, which is not bad. So a lot of experience, and seemed to be pretty competent and pretty reputable from what we saw today. So we're going to start here by taking a look at what the judge had to explain as related to the wrangling going on. So if you can recall, last week when we talked about Derek Chauvin, I think it was Thursday, we did the Derek Chauvin defense strategy, defending Derek Chauvin, defending the indefensible. How would you defend against that? We went through 3 charges, and one of those charges is this third-degree murder charge. And originally, that was thrown out of the proceedings because the judge felt like there was no probable cause to sustain that charge moving forward. And what that means is, if you read the statute, the judge looked at the statute, looked at the language of the statute, and said, yeah, that doesn't apply to the facts here. And the judge's interpretation was because that charge said it was imminently dangerous to others with an S. Others with an S. While Derek Chauvin was just on top of George Floyd, which wasn't others, plural, with an S. It was just one. It was just George. And so there are other statutes for that. And so the judge said, nope, can't bring that charge. Threw that one right out. The prosecutor's office appealed that. It went up to the appeals court. The appeals court said, nope. You can charge that, in fact, because it doesn't mean plural. It means others, like broadly speaking. If there's anybody else, even if it's a singular person, that falls within the categorical definition of others. And so the Court of Appeals said, well, yeah, you can bring charges back. You can bring that charge back and run with it. So now that happened on the verge of trial. Literally, they were scheduled. I think that order came out Thursday or Friday last week. And now the whole thing is just kind of messed up. So the prosecutors are appealing. All right, let me back up. The defense, Derek Chauvin, who just lost that, he obviously does not want that charge to come back. The Court of Appeals said it's coming back if they want to. And Derek Chauvin said, well, wait a minute, I want to appeal that. And so he wants to take it up to the Supreme Court. So it went from the district court where the judge said, no, you cannot bring that charge. Prosecutor took it up to the appeals court. Appeals court said, yes, you can bring that charge. Now Derek Chauvin is saying, no, hold on. We're going to go up to the state Supreme Court. I don't want that charge coming back. So now as this is pending up to the U.S. Supreme Court, or I'm sorry, the state Supreme Court, we're now sort of hunkered down wondering what's going on with the trial. Or should we move forward with this trial? Should we, continue on the other two charges? What should we do? So Derek and his team are appealing it. The prosecution and their team are also appealing it. They've got some issues with this. They don't want to go do a trial on two charges. And what happens with the third charge? What happens if Derek, in other words, if they go forward on the two charges and Derek Chauvin is acquitted, well, now they can, what are they going to have? Are they going to appeal that and say we should have proceeded on all three charges? They just don't know what to do, and they don't want to have to do the trial again. So they're trying to situate how all of these things interplay. They're waiting on the Court of Appeals to give them some guidance. They're waiting on the Supreme Court. The whole thing's a mess. But the judge is basically saying, well, they're going to sort it out. I don't care. We're moving forward with the trial. Judge Cahill is like, well, until we hear differently, we're moving forward. So I think this clip is him explaining a little bit of that earlier today. Let's see if this is the right clip.
All right, we are back on the record. Mr. Frank, would you mind giving us an update on where we're at with the Court of Appeals?
Yes, Your Honor, thank you. We have filed with the Court of Appeals a motion to stay the trial pending resolution of jurisdiction with the Court of Appeals. And in the appeal, I believe it was just accepted moments ago. We've also reached out and made contact with the Court of Appeals, as we had discussed possibly doing. Left voicemails, just making sure they're aware it's coming, and have not heard back yet from that either. So it is filed.
All right. Well, I think I've made it pretty clear that until somebody tells me to stop, I was going to continue on with everything but the murder 3. With that, I think we really do need to hear from the Court of Appeals, and they have not gotten back to you yet.
Correct.
So we are going to recess until 1:30. Hopefully we'll have an answer by then. In the meantime, it's my understanding that counsel are going to get together and go over what motions in limine might be able to be heard at 1:30. We have sent all the jurors home, so we're not going to have any jury selection today, but see if there's anything, if we can go through motions in limine at 1:30, number one. And number two, that you're also going to talk about possible stipulations for certain jurors to be excused for cause based on their questionnaire. So continue to talk about that, and we'll see you at 1:30.
Very good. Thank you.
All right. Thank you all. See you at 1:30.
All right, so that was the first sort of substantive thing that we heard today. They had released the jurors, and what the parties were going to do is come back and negotiate over these things called motions in limine, and we were waiting on the Court of Appeals to give us some guidance on this. I've got an article here just to flesh out this appellate issue. It says Derek Chauvin's defense attorney said that he intends to ask the state Supreme Court to overturn a Court of Appeals ruling on Friday that told the judge, Judge Cahill, to reinstate the third-degree murder charge against the cop. Nelson said he was ready to begin trial with the charge still pending. He expected the petition to the Supreme Court as soon as Tuesday, which might be tomorrow. Said here, I want to inform the court that we're prepared to try this case, he said. It is not our intent to cause delay. However, I feel I have an ethical obligation to my client to petition up to the Supreme Court. Prosecutor Matthew Frank, he returned and responded, and he said, yeah, the proceedings are best to be delayed. This court will be seating jurors for a trial about which we don't know what the exact charges are going to be yet, the prosecutor said. What we are asking the court to do is to stop the jury selection process at this time, and that was granted. So the judge actually did stop the jury selection process. They're hashing out their motions in limine, but they're still on the verge of trial, and they still don't know what the charges are. It's going to get resolved, I think. I think the Court of Appeals and the Supreme Court are going to expedite the heck out of this stuff so that this can stay on the tracks. Cahill contended that the third-degree murder charge is a narrow issue and questioned whether a jury could continue to be seated before that charge is resolved. Waiting for the Supreme Court to rule, the judge cautioned, could delay the trial by at least 30 days, and they do not want to do that. Because, as we showed you at the start of this segment, there are a lot of preparations for this. Everybody is out there. And remember, as I have said, this concept exists that justice delayed is justice denied. And if you are just allowing cases to go on forever, for all eternity, this is why you have a right to a speedy trial. It's why it's pretty important. It's sort of fundamental in our Constitution. We want to resolve this stuff quickly. We do not want this stuff to just sit out and float around forever. And so this judge is really riding that horse. And even in spite of both the defense and the prosecution both saying this is not the right time, we need to continue this thing out, we need more time to sort of solve these issues, the judge said, well, unless the Court of Appeals or the Supreme Court tells me to stop, we're not stopping. We're moving forward as they should. It says here, in the meantime, prosecutors filed a petition with the State Court of Appeals, so they also want to stop jury selection, which has been done. Now, they're supposed to pick this back up tomorrow. Names, we're going to go over that. If trial proceeds, they argued Chauvin is in a, quote, heads I win, tails you lose scenario because he could take his chances at trial. If he's convicted, he can appeal with the claim that Cahill lacked jurisdiction when the jury selection began because he's appealing it. So when he's appealing it, he sort of is pausing the lower level ruling and saying the court doesn't have jurisdiction over me right now because I'm appealing up to the Supreme Court. So if the court moves forward and he loses, well, now he's got an appealable issue. He says they didn't have jurisdiction. They should have waited, like my defense attorney asked them to do and like the prosecutor asked them to do. So now this judge has to he's walking a fine line here. Article continues. It says there is no need for this kind of uncertainty in any case, let alone a case of this magnitude, the state wrote in its petition. So the government is agreeing with the defense. The state is fully ready to go to trial, but the trial must be conducted in accordance with the rules and the law, said Attorney General Keith Ellison, who is now leading the prosecution team. He said this Monday morning today. Now that Chauvin has stated his intention to appeal Friday's Court of Appeals ruling to the Minnesota Supreme Court, as is his right, the district court does not have jurisdiction to conduct jury selection or hear and rule on other substantive matters in the trial. So the whole thing, both sides are saying we got to hear from the Court of Appeals. Meanwhile, the judge paused jury selection, but we moved forward on these motions in limine. And so let's listen in before we get to the motions in limine. We've got this little explanation, I think, here that might help shed some light on what's going on with this appeal issue.
Now, with regard to the motions in limine that are either agreed or stipulated, if you could walk me through those.
So, Your Honor, I think what I'll do is start with the defendant's motions in limine, and then just refer to them by number if the court has them in front of the court.
All right, so let me break this down just a little bit before we dive back into that clip. So motions in limine, these are things that can typically, you can file them early. A lot of attorneys will just file them right on the verge of trial, right the day of trial, like we're seeing here, the day right before jury selection. And basically what they're trying to do is flesh out what the rules are. It's like if you're playing a game of Monopoly, you have to know what the rules are. I don't think I've ever finished a game of Monopoly. I don't know why I use that reference. But the point here is you want to establish what the rules are. You want to know who does what, who can say what, and how this whole thing is going to unfold. So you want to flesh those out before you get the jury seated. If you get the jury seated and somebody in the middle of the trial shouts out something that they shouldn't shout out, now you're having arguments in front of the jury. It could taint the jury. It could result in a mistrial. It could have a whole lot of serious consequences. Things like requiring the jury to forget things, which, nobody can really do. You heard it. The judge might say, strike that from the record, but the jury still goes, what? It's in here. I can't get rid of that. I just heard it. What do you want me to do? Delete it from my memory? I can't possibly do that. And so they're trying to cure and prevent a lot of these issues from manifesting during the course of the trial. They're talking about motions in limine, fleshing out those rules. And there are a lot of them. I don't know how many have been filed in this case. We haven't learned yet, but dozens, maybe 30, 40 different motions. And when I talk about motions in limine, one of the most concrete examples that I give frequently here on this channel sort of will come out of DUI cases. So if you are in a DUI trial and you or somebody you know or love is being prosecuted for a DUI and you want to control some of the rules in that DUI trial, one of the things that a defense attorney might do is say the police officer cannot get up and do anything that's demonstrative in court as it relates to the field sobriety test. So what are field sobriety tests? Stand on one leg, follow the pen, the horizontal gaze nystagmus test, follow the pen, make sure that you're not under the influence, walk and turn, any of those things. And what will often happen in a DUI trial is a police officer who is extremely good at these things, who practices all day, every night when they wake up, every night before they go to bed, every morning when they wake up, they do their walk and turn, they do their one leg stand because they know when they get up in trial, they've got to be persuasive. They got to show the juror and the jury and the jurors how easy it is to just simply stand on one leg. And they do a good job of it. They stand there, they click their boots together, they slam their hands down at the side, and they say, oh, look how easy it is. I can do all of this stuff. Oh, look at the jurors, look at the judge, have a full conversation, perfectly still, standing on one leg with excellent balance with their hands to their sides. Now, if you stand up right now as you're watching this and you try that, you're going to see it's not that easy. And so what a defense attorney will try to do is say that officer can't do that, because they're going to make it look really, really easy. And then when they play the video or when they or describing your client's reaction to performing those tests, they're going to say, well, they just did horribly in connection to what the officer performed. So the officer is setting the standard, and they're going to show how badly your client fails against that standard. And so what defense attorneys will do is they'll just say, well, it's not relevant. Okay, he can describe the test. We don't need him to stand up there and show it because it may be overly harmful and it's not particularly relevant. So that's one rule. And you got to flesh that out before the trial starts. Otherwise, if you're in the middle of the trial and the officer gets up off the stand and goes and walks out in front of the jury and starts performing this test, and you stand up as a defense attorney and start objecting to this, well, now the whole thing looks a little bit messy in front of the jury. The jury may say, well, what is that defense attorney doing, trying to manipulate the rules? What are they trying to hide from me? And that can really jeopardize your case, which is why it's so important that this stuff gets fleshed out prior to the trial starting. And let's go back in and let's see where they're starting today.
Number 1, which regards since we're looking for from our court, the appellate court. So
Now, with regard to the motions in limine that are either agreed or stipulated, if you could walk me through those.
So, Your Honor, I think what I'll do is start with the defendant's motions in limine, and then just refer to them by number if the court has them in front of the court. The motion number 1, which regards sequestration of witnesses, the court may have already answered this in its order. I would also at this point refer the court to defendant's motion 16, because it also deals with sequestration in a sense, more specific to this case because of the live feed. We agree to sequestration, Your Honor, and one of the questions we typically run into in various courthouses is what exactly sequestration means, whether it means a witness can start watching after they testify, or they can never watch testimony and still be recalled as a witness. I don't know how this court's preference is, but I think we are of a mind that a witness could not be recalled if they watched any amount of testimony after their own testimony, with one exception I'll get to. So if that's consistent with the court's understanding, that is what our understanding is about sequestration.
So you agree that after a witness testifies, they may watch further proceedings?
They may not watch and still be called back as a rebuttal witness. All
right, that is my general practice, so we're all on the same page there.
And the one exception that we have discussed is expert witnesses.
All right, so they go on. You can see how slow rolling this stuff is. Kind of painful to watch. You can synthesize this stuff down pretty quickly. They're talking about sequestration. George Floyd was killed on the side of the road. Tons of witnesses, a lot of people walking by, a lot of evidence. I think they were talking 300 to 400 different witnesses, potentially. Different names, people who were walking by, people who claimed, who sort of were there. They were on the side of the road for a long period of time. So a lot of individuals. Now, the question is, if a witness is called into court and testifies, and they are done testifying, what can they do? Can they go back out and watch the live stream? This whole trial is going to be broadcast on YouTube. Can they go watch it? Or can they watch it before they come in and testify? Well, no. The answer is no, they cannot. Why? Sequestration. They don't want them to communicate with one another, and they don't want them to know about the other things that other witnesses testified about. And you see this a lot, right? Well, oftentimes you'll do this even with police officers. You'll say, no, they all got to get out of the room because we're going to call one witness in at a time. You don't want the officers to hear what the other officers are saying so that they can concoct a story. That's from a defense perspective. From a prosecution perspective, they may want the same thing, right? If one defendant's on trial and they've got 5 other witnesses in there who are going to come in and support the defendant and say, no, he wasn't there at that location at that time, he didn't do any of that stuff. Well, you're not going to have them all sitting in court together, listening to each one after the other testify, so that the last person who is the witness comes in and just corroborates everything. Yeah, I heard everybody. Everything is right. You want independent recounts. You want independent testimony. And so they just decided here that if a witness is brought into court, then they cannot be a part of the streaming of the trial. They can't know anything about it before or after, except for expert witnesses. Expert witnesses, however, can hear everything because they need to hear what other people are testifying about so that they can rebut their claims. So if the government witness here, who is prosecuting Derek Chauvin, is listening in to Derek Chauvin, the defense, his expert, come in and testify that George Floyd was killed because of fentanyl, for example. Well, he's got to hear that. He's got to hear that testimony, and he's got to hear how the defense is using that so the government witness can come in and rebut that allegation, and they can only do that if they hear it. So sequestration was the first one. The next one that we have here is regarding names. So this is a pretty important detail. What are you supposed to call people? What are you supposed to call George? The government here presumably wants to use language that serves their interests. So George Floyd was killed. He was murdered. He was a victim. He is dead, right? Those are sort of provocative words. We sort of saw an example of this in the Kyle Rittenhouse case, where the judge there in that case is refusing to allow the prosecutor to call the people who were killed as a result of the shooting victims. Judge said, no, they're not victims yet. It hasn't been decided that they are victims yet. Kyle Rittenhouse is still innocent until proven guilty, so you can't call them victims. Prosecutor Binger over there didn't like that, but it's that judge's rule. In this case, judge seems to be pretty okay with allowing the word victim to be used, but they are going to default to names. So rather than being specific about it, names. They're going to use George Floyd's name instead of victim. They're going to use Derek Chauvin's name instead of a police officer, right? Because one carries a little bit more weight to it. If you think about a police officer, you might think, if you're a juror, well, they're pretty respectable people. They've got a lot of credibility. They've got good opinions. They're out there trying to serve the community and all of those things. So if the defense just kept referring to Derek Chauvin as Officer Chauvin, then that's going to create this connection. It's going to create this idea just using that language. And so the government doesn't want that. And the defense doesn't want it either, because if they're allowed to call Derek Chauvin whatever they want, then the prosecutor can call George Floyd whatever they want. They can say, well, he's a victim. He was killed. He was murdered by Derek Chauvin. So they're just fleshing out what this language looks like. And here is another clip from that interaction.
All right.
Your Honor, motions 2 and 3 are really, I think, kind of decorum motions. I was taught quite a while ago now that we are to use names in the courtroom rather than terms like victim or accused. And so, we don't have any problem with these motions. We would agree to them, and to call people in the courtroom by their last names as much as possible. I would, Your Honor, this is, I think I've shared with this court before my concern about motions of this kind that are, trying to set up appellate issues later potentially. We will instruct our witnesses. We will ask them to abide by these rules, but we have a limited control, of course, over what tends to be very common ways for people to refer to other parties in the criminal justice system. We agree with these motions in theory, and we will do our best to have witnesses abide by them, and would ask that, that if there are circumstances where these terms are used, that a contemporaneous objection or that it be brought to the court's notice contemporaneously so we can deal with it at that time.
Well, I'll just comment on that, both my practice and what I think it is most appropriate, because I think it's most respectful to refer to people by their names. So, for example, not victim or deceased, but as George Floyd, for example. I think it is much more respectful to call people that way. However, I also don't want to micromanage the language used by counsel if there is a reasonable basis in the record to say so. So I actually do allow the state to say victim. I do allow the defense to say something other than that to describe, for example, in this case, Mr. Floyd. I do allow the state to use the term defendant, and Mr. Nelson, I'm sure, will use Mr. Chauvin. So I agree. I think it is respectful, and I'm glad you agreed to this because I think it is more appropriate. But at the same time, I don't think it creates an appeal issue because I don't put those restrictions on the speech of the various lawyers. So with that, next.
All right. So very interesting here. The judge is basically saying, yeah, ordinarily I would allow a little bit more leeway in my courtroom about what names you can use. Prosecutor, if you want to use victim, you're free to do that. Defense, if you want to use the accuser instead of the victim, or if you want to use the decedent instead of victim or whatever, you're free to do that. And it's not going to cause an appealable problem. So what the prosecutor was concerned about is he said, look, yeah, we're agreeing here that we're going to use names. We're not going to use colorful labels for people. We are just going to use names, but I just can't control every single thing that my witnesses say at every given moment. So if somebody does come out and they do call him something like a victim, he's concerned that maybe the defense will say, whoop, we entered an agreement. We had a motion in limine here. We agreed we weren't going to use those words, and you did. Therefore, mistrial, appeal, we're going to take this thing up to the next level. And so he's concerned about that. That judge said, oh, it's a valid concern, but ordinarily, even in the ordinary course of business, I would just allow those types of names to happen in my courtroom, and I would not consider that to be an appealable issue. So, largely it sounds like, both sides are trying to work together to have a civil trial, which is a good thing, and the judge is just sort of establishing what those standards are. The next motion in limine, before we get there, I wanted to show you this clip. We see here Derek Chauvin in court, and this is his defense attorney, Mr. Nelson, and they're sort of communicating here. Nothing really to glean out of this clip, but I just wanted to show you this different angle so you could see Derek Chauvin sitting there and what he looks like. I think in this little clip, he starts to write something down, right? Who knows what it was, but here he is. And they're talking about hearsay. They're talking about discovery, about background checks in particular. They're saying that if the prosecutor's office here, if they're doing their investigation into jurors or other witnesses, if they're doing a proper investigation, they're also doing background checks. And so they're having a little bit of an argument about, well, whether the prosecutor has to disclose those background checks over to the defense. And as it relates to witnesses, the government is saying, sure, we can do that. If it's a witness that we intend to call, we'll let you know if we did a background check and we found anything about that person. But as it relates to jurors, they do not want to release that information. They say that's work product and we're not going to give that stuff out. The defense, they can do their own research on the jurors if they would like to. That's not our obligation. And let's listen in and see how they conclude this.
Has been complying with the Rule 9 requirements. I'm sorry, I should stand.
Actually, why don't you sit but pull the microphone closer to you?
Sorry, just the glare through here too is kind of difficult. So, Your Honor, with respect to number 8 and number 9, I understand that the state has an obligation to provide us with substantive statements that witnesses provide. I would note that it appears that the state has been doing that through various BCA reports that I've received. So I'm in agreement with how Mr. Frank articulated his obligations under Rule 9.
Okay.
All right, so that was mostly a non-issue, but I just wanted to show you that angle. Okay, so this is a very interesting, we got two interesting clips. This one's a little shorter. Then we have another one that's long, and I'm not sure how long I'm going to let it go, but I wanted to show it. All right, so this first one is where we're talking about an analogy. This is very interesting, and this judge actually gets a little bit pointed here. So this is the prosecutor, this is the government now talking about a motion in limine about one particular witness and how they phrased their interpretation of an event. All right, and what we're talking about here is an analogy. And I don't know what the specific language is because this witness has not been called and this has not been presented in a court of law. But the judge is reading the motion in limine. And you're going to see he goes, wait, what? Why are we even talking about this? Why is this language even in writing in front of me? And the prosecutor says, well, it's because it's a very specific victim. And what they said is very applicable in this really narrow little window. I know what it says is just bad. It's really bad, but it's applicable and appropriate in this one little context. And so we know we have to flesh this out, because if this witness comes into court and testifies about this, this could cause some fireworks. So they're trying to work it out. And I don't know exactly what they're talking about, but you're going to hear the judge, and it happens quickly, so listen for it. The judge goes through and he says, there is absolutely no way that that analogy comes into court. Absolutely no way. And you're going to see he says it's because Rule 403. What that rule means is that it's way too prejudicial. The language is so volatile. It's so explosive that the judge is not going to let it in. In other words, he's saying that it is more prejudicial than it is probative. It's not going to add any value. If that witness comes into court and testifies in that way, it's going to cause way more harm than good. And so we're not going to allow that statement to come in. And so the judge basically directs the prosecutor, hey, you better tell your witness he better not use that language. If he wants to come in and testify about this stuff, that's fine, but he cannot say that. I don't know what they're talking about here. I don't know if the motion in limine has been released yet, or if we see any of these stuff on public record yet. But when I was looking earlier, I couldn't find it. And I don't know what it is, but you're going to see he talks about a hanging. He talks about asphyxiation. So I think it might be a reference to lynching, but we don't know yet. Let's listen in here on this clip.
Agree that specifically as worded, the court could grant this with respect to the, shall we say, parties identified specifically in that motion.
I have to ask, how did this even become a motion? How did this become a possible answer at trial?
I think, Your Honor, one of our witnesses mentioned something like this. We do not, in context, Your Honor, I don't really want to go into.
Fair enough.
It was not inappropriate the way it was brought out, because of course this case can be about asphyxiation. Hanging is a form of asphyxiation. There will be testimony in this case about asphyxiation. One such proper testimony about that.
Right.
Drawing a comparison to this particular person, we do not intend to do. Does that make sense?
You can prepare your witness by telling them that analogy absolutely will not come anywhere close to being admitted.
Really understood, Your Honor.
Under Rule 403.
Yep.
All right.
That judge was not happy with that. Okay. Tell your witness that will not even come close to being admitted. Do you hear me? He says, yes, Your Honor, I understand that. Judge goes, next. And you heard him there at the very end. He tailed off. He said, Rule 403, it's more prejudicial than it is probative. The harm outweighs the benefits, and so that is not coming in. So we don't know what that is or who that witness is or what that testimony is about, but judge wasn't happy about it. Then we have another clip here. Let's see what this one is.
I'll read your notes. Don't worry.
Yes.
34, Your Honor.
So let me frame this one out just a little bit more. So this is his attorney. This is Eric Nelson. Very interesting little clip here. So what they're talking about now is Rule 404B. It's called propensity evidence. It's this idea that you can bring in prior bad acts. So previous things that have happened. If you can, they're asking the court, can we talk about those things? Can we talk about George Floyd's prior arrest? Can we talk about prior incidents where George Floyd has had interaction with other law enforcement officers? Any other time that he's been in the hospital? Similarly, can we talk about any of this stuff about Derek Chauvin? He's got a lot of other disciplinary proceedings. I think 17 of them. We've talked about them many times on this channel. Many of them have been closed, but the prosecution, they may want to bring that stuff in. They may want to say, well, look, he's got all of these other knee on the neck incidents, or he's got all of these other racially charged traffic stops or whatever, in order to show their case. They want to say, look, he has a propensity to commit this type of action, and we want to bring that into court to show that potentially here in this case, he was acting in conformity with those prior incidents, with his past experience. And so what Eric Nelson here is going to do for Derek Chauvin is he's talking about a prior situation with George Floyd where he was arrested and sort of ingesting drugs at the last minute. And I've not heard this before. This is him talking about other cocaine or fentanyl and methamphetamines, I think it was. We're going to listen in on him a little bit here in a minute. But the judge is basically saying, you can't talk about any of that other stuff. Okay, in 2019, there was another incident, other prior incidents. The judge says none of that is coming in. And the reason being is because it doesn't go to the question that's being asked here. Did the drugs kill George Floyd today, on that day, in May 2020? Did they, or did Derek Chauvin kill him? And what you're going to see here is this defense attorney is trying to show you that George Floyd, his prior bad acts, his prior usage of drugs, his prior interaction with law enforcement, he's trying to say that's relevant. It's totally relevant because in this case, we could show that this is his same modus operandi. This is just how he is. He just consumes a bunch of drugs and anytime he has an interaction with law enforcement, and that's what resulted in him dying. So they want to show you that back in 2019 when he did it. They've got evidence of that. So if they can prove that case, and maybe they can show that the 2020 case was in conformity with the 2019 case, and they want to get that in front of the jury, and rightfully so, because it is very, very, very prejudicial towards the government's case. If you can establish this idea that George Floyd just, anytime he sees the police, just ingests whatever drugs he has on him, well, that sounds pretty reckless. It sounds like that might be something that kills you. And what they want to do as a defense is show that that's exactly what happened. They can't prove it here in this case, but they want to show you back in 2019 that that's exactly what happened and sort of use that to show that it happened here. And so the judge is going to say, nah, I'm not convinced about it. This is a long clip. It's like 4 or 5 minutes, and I even sped it up, but I think it's worth watching. Let's listen in, and we'll see how long we can go before I get bored with it. Here it is. Here's Eric Nelson talking about that today.
A request to make an offer of proof. The court previously dealt with, obviously, the 404B motions that we brought relevant to the May of 2019 arrest of Mr. Floyd.
May 2019.
The court, in its order, it issued sort of a summary order and had indicated that a memorandum would be filed by the court stating the reasons why certain 404Bs were admitted and others were rejected. We've just not received that order. What I expect, however, Your Honor, is that there has been significant developments in this regard, at least with respect to the defense perspective, that we would like to supplement our record, ultimately ask for reconsideration of based upon that new information. That was not available at the time that we brought that motion.
All right, let's go ahead and do that now.
Sure.
All right, so real quickly, he's saying previously, we submitted a motion asking that we could talk about that prior bad act, which was back in 2019. I think it might have even been in May. He said, we submitted it. Court said, well, on some of this stuff, some of it comes in, some of it goes out. Some of this prior bad act, some of these prior incidents that you want to talk about, we're going to let some of them in, we're going to let some of them out. So this attorney says, well, I didn't get the memo. I don't know why you kept some of them out or whatever, but it doesn't matter. We have new evidence on the one that you denied. We wanted to talk about that May 2019 case. Remember, George Floyd died May 2020. We want to talk about this prior case. You denied it, but now I'm asking for a renewal. And I want to provide proof to the court to show you why we need a reversal of your prior motion. So the judge already said, no, that's not coming in. He says, yeah, but we have new evidence. And then this is where it picks up. Judge says, okay, well, just bring it up. What do you got? What do you got for us? And here that is.
So, Your Honor, and again, I'm simply, I am speculating as to the court's rationale as to why the previous arrest of Mr. Floyd was denied. However, my speculation is that the court considered our analysis, our statement of facts to be somewhat speculative as to whether or not Mr. Floyd had drugs in his mouth at the time of his arrest. Since the court issued its order, the defense discovered and went and inspected Squad 320 of the Minneapolis Police Department. In reviewing photographs of Squad 320, there appeared to be white substances throughout the back seat of the squad car. So myself and some of the other defendants' attorneys and our investigators went to inspect Squad 320. It was very apparent that what was...
Well...
I won't read your notes, don't worry. Yeah. 34, Your Honor, is just our request to make an offer of proof. The court previously dealt with, obviously, the 404B motions that we brought relevant to the May of 2019 arrest of Mr. Floyd. The court, in its order, it issued sort of a summary order and had indicated that a memorandum would be filed by the court stating the reasons why certain 404Bs were admitted and others were rejected. We've just not received that order. What I expect, however, Your Honor, is that there has been significant developments in this regard, at least with respect to the defense perspective, that we would like to supplement our record, ultimately ask for reconsideration of based upon that new information. That was not available at the time that we brought that motion.
All right, why don't you go ahead and do that now?
Sure. So, Your Honor, and again, I'm simply, I am speculating as to the court's rationale as to why the previous arrest of Mr. Floyd was denied. However, my speculation is that the court considered our analysis, our statement of facts to be somewhat speculative as to whether or not Mr. Floyd had drugs in his mouth at the time of his arrest. Since the court issued its order, the defense discovered and went and inspected Squad 320 of the Minneapolis Police Department. In reviewing photographs of Squad 320, there appeared to be white substances throughout the back seat of the squad car. So myself and some of the other defendants' attorneys and our investigators went to inspect Squad 320. It was very apparent that what was in Squad 320 was controlled substances. The state of Minnesota then subsequently had those substances taken out of the squad car and tested. They are, in fact, methamphetamine and fentanyl, and they contain the DNA of George Floyd. So they are partially chewed up pills. In addition, Your Honor, the additional evidence that was discovered, the state executed a second search warrant on the Mercedes-Benz that was being driven by Mr. Floyd, and located in the center console of the Mercedes-Benz were 2 pills that were identical to the 2 pills that, or appeared to be identical to the pills that were in Squad 320. Those pills were analyzed, and those pills also contained methamphetamine and fentanyl. So ultimately, if we look at this particular incident, in what the state argued was speculative, that our screenshots that we had submitted to the court in connection with that 404B, was it gum, was it something else, was it drugs? I think the question has been answered, that we now know for a fact that there were drugs that were in the car. We know that there were drugs in the squad car that contained Mr. Floyd's DNA, and that those drugs in both of those cars were identical to the drugs that were in Mr. Floyd's system at the time of autopsy. So in that regard, Your Honor, if we liken it and we go back to what happened in May of 2019, when Mr. Floyd was pulled over with a large amount of drugs in his mouth, he was taken into a squad car. He was then ultimately hospitalized, where he had to be physically restrained by hospital staff. And so it would be our intention to provide the court with all of those additional records, just simply as a supplemental offer of proof in that regard.
And you can make that offer of proof by filing those, but the question I have for you, and this is so you don't have to speculate as the court's ruling, what 404B exception does all this go to? What does it establish that is an element of the crime here?
Well, it establishes a modus operandi, essentially, of Mr. Floyd, and when Mr. Floyd is apprehended, or at least in one prior incident, when he was arrested by the Minneapolis Police Department, he did the exact same thing that he did here. And when we get into the question of his cause of death, is he actively ingesting narcotics that would potentially cause his death?
Well, does it really go to that, though? And I'm asking this, you know the file better. It could have been. I don't think the state's contesting the fact that fentanyl and methamphetamine were found in Mr. Floyd's blood after his death. Is that correct, Mr. Frank? And the amounts, I think, are what Dr. Baker is going to talk about. Why does it matter that he took it in response to police action, that is the police coming up to his car, versus maybe 15 minutes before or an hour before?
Sure.
The bottom line is, they're drugs, they're in a system, unless you're claiming, or the state's claiming that someone involuntarily intoxicated him by essentially forcing drugs on it. I don't see how it establishes.
Because, Your Honor, and perhaps this is the missing component, because ultimately what is being said a lot about this particular case is that the Minneapolis police overreacted to a $20 counterfeit bill. But what people in our line of work, whether it be the court, the defense, police, the state, we understand that these are fluid situations that often evolve. Maybe an initial very minor report, but when the police go to intervene and suddenly you learn that there are drugs in the car or guns in the car, I'm not suggesting there were guns in the car here, because there weren't. I'm using this as a general example. Or there are warrants for someone's arrest. These are evolving situations that call into question the amount of force that police are authorized to use. And so it's a lot different if you're trying to conceal or secrete controlled substances than it is, a $20 bill. This isn't just a $20 bill. And it ultimately goes to the very nature of the police response.
Well, and as I understood it in our September motion hearing, there is not an assertion by the defense that Mr. Chauvin knew or had arrested Mr. Floyd as part of that May 16, 2019 incident.
Correct.
And
But
then-
if you look at If you look at the 2019 response, right? The Minneapolis police pull him over. The officer draws his firearm immediately because Mr. Floyd is not showing his hands. And I know that in this particular case, Officer Lane did that exact same thing. It goes to the measure of the police response to that particular situation. So if we're going to come in here, we're going to have experts from Los Angeles and Montana and wherever else they're coming in from to say this was an unauthorized use of force. And you have a prior incident where officers used an identical use of force in an almost identical situation, that's where it becomes relevant.
You can make your offer proof. We can revisit it later, but I'll be honest, I'm not convinced. I could see where that evidence might be proper if you had said Mr. Chauvin was part of that arrest or knew about that arrest, and therefore when he had the contact with Mr. Floyd that resulted in his death, I could see where it'd be like, oh, this is what he does. I have knowledge that this is how George Floyd reacts to police interaction. But it doesn't establish that because Mr. Chauvin wasn't a part of that arrest.
Understood, Your Honor.
It's more of a generic, let's pick a situation because we have a body-worn camera and Mr. Floyd on it. There could be other body-worn cameras that show that that's not how the police react to it. So I guess I'm telling you right now, I'm not convinced yet to reverse my ruling, but I'll consider whatever you have as far as written offer proof.
Thank you, Judge.
All right. Thank you, Mr. Nelson. Mr. Frank.
So this goes on. The prosecutor comes back out and he says, well, I have some facts that I would like to dispute about that. I don't think that the defense attorney's synopsis was fairly articulated about what he claimed had happened previously. And the judge ultimately says, well, look, this is why I'm kind of holding the standard here. I'm saying that we're not allowing any of these prior bad acts in regardless. We're not letting it in for George Floyd. We're not letting it in for Derek Chauvin. Prosecutor, you can't talk about Chauvin's prior history. Defense, you can't talk about Floyd's prior history. And the judge is just kind of setting that standard. But that's kind of, I think that's important and it's relevant, but the bigger takeaway here is what I think we can glean from this defense attorney and what his perspective is on some of the evidence that he's going to present. I mean, if there really is evidence that in the police cruiser there is fentanyl and methamphetamines that were chewed up by George Floyd and they're sort of spread around the back of the vehicle because they have his DNA. If that is something that is going to be admissible, that is a really, really troublesome fact for the prosecution. And I think what this defense attorney was trying to do, but he was a little bit inarticulate on it, was to show that George Floyd, by his prior act in 2019, what this defense attorney was trying to do is say, look, anytime there's a police response, George Floyd just consumes whatever drugs are in front of him. And that's a different situation than if George Floyd was using drugs recreationally and he was just fine and he was sort of apprehended in the middle of a very stable, steady high that somebody might have if they're using drugs recreationally. That's a whole different scenario than if somebody is cramming mega doses of drugs down their throat because the police are right around the corner. And the jury's going to have some questions about that. So here it sounds like the judge is saying, well, the first part of this evidence can come into court. You can talk about the sort of the white powder that was scattered around the back of the police car. That is okay, but you just can't talk about that 2019 case because it's just not relevant. Because Derek Chauvin wasn't a part of that 2019 case. And it just doesn't establish anything. Whether George ingested a bunch of drugs here at that date and time is pertinent to his cause of death on this date and time, but what happened back in 2019 is just not relevant. I'm not so sure that I agree with that. I think that actually that defense attorney is right. If this were a situation where George Floyd was following the same method, the same methodology that he did back in 2019, where apparently he was hospitalized at some point for the same type of problem, I think that is very relevant, and I think the jury would want to hear that. But of course, the prosecutor does not want that to be heard. But very, very interesting evidence. If the defense is going to be presenting that, that's not good for the prosecution. All right, let's jump into some questions over from locals.com/watchingthewatchers. First question comes in from It's Ed. It says, hey, Rob, hi, Miss Faith. While I agree that we need justice reform, I think we also need some form of cultural reform. How different would things have ended if George Floyd didn't resist? I'm not justifying what the officer did, but if we continue to promote the idea that we shouldn't follow instructions given to us by an officer, then we are doomed to see these events occur more often. At least if Floyd didn't resist, no one could say there was any justification for that level of physical interaction from the officer. Part two. Well, it's Ed, I appreciate that, and I understand what your argument is, and I don't want to to be too overly aggressive in my response, and I'm not intending to do that at all. I just think that what we saw in George Floyd's case, and George Floyd may not be exactly what you're talking about. This is just something that is the current news. But I think the response to your statement would be that there was a period in time in which George Floyd was no longer a threat at all, right? He was on handcuffs. He had 4 officers on his back. The knee was on the neck for, 8 minutes and 46 seconds. At some point, he passed out, and the continual use of force is just no longer necessary. And I think that's what people are mostly upset about. I think that most of the country would excuse a little bit of physicality from the officers trying to subdue somebody. George Floyd's a big guy. I think he's 6'4", right? Big guy. And so I think at some point people would excuse the physicality of that. They would say, all right, you got to take him to the ground. He's resisting arrest. Okay. But there was a point when the tables turned. There was a point when George Floyd just started to die right in front of us, and the police did not respond appropriately. That's when it just flipped, and everybody just said, all right, that's enough. That's too much, right? We can tolerate a little bit of physical overreaction, but when that line is crossed, then everybody just sort of recoils and is just sort of massive amounts of gross feelings. My words fail me on it, but it was just such a difficult thing to watch that there was really no justification for it. And I think that is what people are responding to. They just saw that and they said, no, there's nothing that excuses that, which is why this is being prosecuted in the manner in which it is. As to your other point about, cultural reform, I think that, I think a lot of the reform, in my opinion, should start with law enforcement. I think that for a very long time, they have been discriminatory. You can agree or disagree with that. I live in this space. I think that it is true. We represent a lot of people in this space. Not every single cop is a racist cop. All right. That's also not what I'm saying. I am saying that there are some serious cultural reforms that are necessary, I would say, within law enforcement, right? Not every time that they respond does it have to be like they're in a war zone in Fallujah in Iraq in 2003. It doesn't have to be like that. They can actually help people. They don't have to go out there and kill people and break things. This is a civilian law enforcement police force. And I think that, yes, there's a lot of room for repair between the African-American community and the police community. I'm not necessarily sure that we should put the impetus on the African-American community to, step it up or whatever, or, engage in cultural reform or just abide by the police. I think that the police should justify their reason for being there and for stopping people and for interacting with people. Not everybody should just drop to their knees and fall prey to their police officers and law enforcement around this country, right? They have total monopolies on power. They control a lot of whether people live or die, whether they get charged or not. They have a lot of power. And I don't like the idea that everybody just bows down to power. I think the police have a lot of have a lot of work to do to repair their image, their relationship, and how they actually enforce the laws. Once they start on it, then we can start having conversations about the other communities around the country. But it's got to start with the police. Good question, though. Heavy question, it's Ed. Starting us off with a heavy one. Jeremy Matrita in the house says, Robert, what is the difference between video evidence and eyewitness as far as presenting a prosecution or defense? Can someone testify contrary to what is seen on video? It's a good question. And so you're kind of talking about, eyewitness testimony is preferred over everything. So I'm not sure how much of the video we're going to see or what angles of the video we're going to see. We are, I'm sure, going to see the George Floyd video, the main one, right, that we all sort of saw. But typically you want witnesses or, so with video evidence, you got to lay a foundation. You got to be able to, get it in over objection. The defense is going to make a bunch of objections. I think the judge lets it in anyways. But ideally you have eyewitnesses. You have people who were there to testify about it. So they would lay the foundation for the video, then they would get the evidence admitted, the video admitted. And the reason why that's important is because the defense needs to be able to cross-examine the witnesses, right? Under the Constitution, we have a confrontation clause, which means you have the ability to confront your accusers. It's hard to do that with video. It's hard to do that with a picture. But if you can lay the foundation, if you can have other people who recorded the video come in and testify, then you can cross-examine that person. And if they lay the appropriate foundation to say, well, this is where I was, this is how I took the video, it's my phone, I didn't move, and they can explain it, then they can get the foundation laid so that the video can come in, and the cross-examination will take place on the witness, not on the video. But they could have their own expert witness, let's say, come in and give an alternative explanation of the video. They could say, well, at that point, George Floyd was dying because the fentanyl he consumed, whatever. So it's a good question. We're going to have a lot of battles over the video evidence, I think, as this trial unfolds. Next question comes from Jeremy. If the judge precludes Proyd's prior convictions, can the defense argue the same for precluding Chauvin's prior arrest using the knee? Hopefully I'm using the word preclude properly. Yeah, you can. And I think that this is exactly where the judge is heading with this. I think that the judge is not inclined to allow any prior bad acts from either party on either side. All right, and so that's what's going on with George Floyd and Derek Chauvin. We will see how this continues to unfold. We're going to be following this one very closely. So make sure you subscribe. Make sure that you follow us on all of the socials, because we'll be talking about this for the foreseeable future. And we're going to change gears a little bit. So not every show is going to be just packed with George Floyd stuff, but a lot of it is, because it is sort of a very important trial in this year.